So the Supreme Court has denied review in another Second Amendment case, which deals with a challenge to the state of New York's denial of a concealed carry permit. So let's talk about this. But real quick before we jump into this video, if you think states like New York need to stop violating the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit the website link down below. And thank you again, SDI, for sponsoring this video. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. As I mentioned in the intro, in this video we will be discussing how the Supreme Court just refused to review another Second Amendment case. The case we're going to be talking about in this video is called Valdivia v. the City of New York Licensing Division. This case arises out of the old standards in the state of New York and in the city of New York, and that they used to use to grant and deny concealed carry permits. This case was the result of the New York City Licensing Division denying an unrestricted concealed carry license to a police officer because they deemed that he did not meet the proper cause standard. Now, for those not aware, there was a prior case which already struck down the old New York concealed carry may issues permitting scheme, and that was the New York State Rifle and Pistol Association v. Bruin case. The state of New York used to require that a person provide proper cause to be issued a permit to carry concealed. The issue was that the state of New York did not consider self-defense a proper cause, and therefore on that justification alone, people had their permits denied. In Bruin, the Supreme Court struck down this New York may issue licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of Bruin and that decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of this nation. However, despite that decision, the state of New York refused to even comply with that, and they rushed through a new law, and many of you are familiar with it. It's called the Concealed Carry Improvement Act, or the CCIA. Instead of rolling back their concealed carry laws, the state of New York doubled down on gun control and created a scheme even worse than the one that existed prior to Bruin. This new law in New York created a more restrictive application process and then made it so that everywhere within the state of New York is likely considered to be a sensitive place, effectively making your permit useless even if you got one. That new change in law is currently being challenged in multiple cases. One of the most popular ones right now is the Antioch case. We've covered those at length on this channel and other videos, so if you're interested in that, you can find some of those other videos where I covered those issues more in depth. However, this case is a carryover case from the old New York may issue scheme and proper cause standard. The petitioner in this case filed a pro se writ of certiorari up to Supreme Court, which essentially means that he's representing himself. He doesn't have an attorney. The facts around this case are a little bit blurry, but what appears to have happened is that Mr. Valdivia applied for and was approved and issued a restricted business carry license back in 2012. After having his permit for a while, he then went to go once again renew his permit back in 2018, but this time his permit was denied. His renewal application was denied on the basis that the licensing division did not believe he had proper cause and did not meet that standard. In reaching that determination, the licensing division found that Mr. Valdivia is not in danger in the same way that a diamond dealer would be, who's walking down the 48th Street, the Diamond District, I believe, with a briefcase full of diamonds. So they believed on that basis alone, his application did not meet the proper cause standard, and therefore his application was denied. He then sued for reconsideration of the licensing division's determination in state court, since he argued that their decision was arbitrary and capricious. This case then made its way through the appellate process, where ultimately the courts found that the denial of his application was not done in a way that was arbitrary or capricious. However, while this case was going through the process and during the lockdown period, Mr. Valdivia was hired by a municipality near his home, and he became an active sworn police officer. Mr. Valdivia still serves as a police officer and also still has his side business that he was initially granted that permit for. Despite being an active police officer, his unrestricted license to carry has still not been granted. And in response to all this, Mr. Valdivia was then seeking Supreme Court review of his case. The main question presented to the Supreme Court for review was whether or not the licensing division is empowered to deny an unrestricted concealed carry license to a qualified police officer who seeks to have such a license. Mr. Valdivia argued that the prior proper cause standard led to an invalid determination that he should not be granted a permit, and even more so, he argued that now under the Law Enforcement Officer Safety Act, the LEOSA Act, the denial of the licensing division should be determined to be improper. Now, in the last videos when I talked about this case, many of you commented, why did he even need a permit because he's a law enforcement officer? That is because he had a permit and it was granted back in 2012, and he was renewing that permit, and that all happened before he actually became a law enforcement officer. The LEOSA exemption does apply to him, but I assume he wants a permit to meet other types of restrictions, other types of qualifications that the state of New York has, like being able to purchase a handgun. In reaction to this case, the state of New York licensing division filed their response arguing that Valdivia's challenge to the denial of his licensing application does not properly present any question of federal law and any question of law that needs to be reviewed by the Supreme Court, and therefore they should deny review of this case. Although Mr. Valdivia now seeks to challenge the denial of his application under the Law Enforcement Officer Safety Act, the state of New York argues that the statute and that argument did not make an appearance until much later in the filings, and therefore it's not a valid argument for him to now bring up to the Supreme Court. Then the licensing division argues similar to how I said they would likely argue, and that is that after the Bruin decision, the state has passed the CCIA, which they claim now moots some of the claims that are being made in this case. Mr. Valdivia recently filed his response to those arguments, and his main contention appears to be that the new CCIA law still does not address his specific situation where someone is a New York resident but has an out-of-state police officer employment, and so he's arguing that the CCIA laws do not cover his specific situation. He also argues that the Supreme Court's decision in Bruin did not fully close the door on these types of permits and this type of issue, and that's evident by the fact that current efforts by states like New York in creating new laws are being done in a way to circumvent that very decision. So he's arguing that the Supreme Court should dip their toes in this issue once again and reaffirm what they said in Bruin. So the question with this case was whether the Supreme Court would decide to grant review on this issue, on this case, or whether they would simply grant, vacate, or remand the case in light of their Bruin decision, or simply would they outright deny review of the case. Well, we received a decision from the Supreme Court, and they have denied review in this case. That's not super surprising, since if you watch some of our prior videos, I said that it was much more likely that they would deny review in this case. It's a pro se case, and also the Supreme Court just simply doesn't take up a whole lot of cases. They are presented hundreds and hundreds of cases every single month, and they only take up a very select few. And it wouldn't have surprised me if they denied this case. I kind of expected they would, and I think the best case scenario for Mr. Valdivia was that they would grant, vacate, and remand this case in light of Bruin. But ultimately, the Supreme Court has denied review in another Second Amendment case. So for now, in a post-Bruin world, the Supreme Court has not taken up any other Second Amendment cases. They could be waiting for a case to eventually reach them that's been fully briefed in light of their Bruin decision, but also keep in mind that since that Heller decision, which happened in 2008, and the Bruin case, which ultimately didn't happen until this year, there was a huge span of time between those two cases. There was 14 years, and that's a 14-year spread. So we could be in for another long wait if the Supreme Court feels like they don't need to address any more Second Amendment issues. Recently, we talked about them denying review in a bunch of bump stock cases and some other cases as well. So it's still yet to be seen whether or not they're interested in taking up any more Second Amendment cases. They will be presented opportunities likely next year as well. So we will have to wait and see whether or not the Supreme Court has an appetite to actually hear more of these Second Amendment issues. But for now, they have denied review in another Second Amendment case. So that's what's happened in this case. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algor's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.